her feet and then either challenge Mr. Speaker. If you want to challenge Mr. Speaker, you have to come by substantive motion. But you cannot also, rise up and now comment on what Mr. Speaker has said. That is the procedure and the practice in the House. So when he wanted to challenge Mr. Speaker, Mr. Speaker told him that, he was not going to give him leave to challenge him. So there was no appeal, properly so-called. There is no notice of appeal before any, court of competent jurisdiction for there to have been a stay, of execution. All right. Now,
in fact, and we are putting the facts out for you as far as we know them. In fact, the suit was instituted on the 15th. The Speaker's decision was taken on the 17th. Correct?
Right.
Thank you.
Yeah. So that is also one aspect which I will come to shortly. But I want to deal with the issue of jurisdiction. The reason I'm talking jurisdiction is because this is very important. The subject matter of the suit before the Supreme Court relates to the declaration of vacancies. All right, because Mr. Speaker had said that vacancies had occurred in these 4 constituencies, and he was informing the House pursuant to Order 18 of our standing orders that vacancies had occurred. Now, let's even say that the suit that was filed prior to the response of Mr. Speaker or the ruling of Mr. Speaker correctly identifies the act or omission of Parliament that has to be dealt with by the Supreme Court. All right. The issue that it is raising is one in relation to the declaration of vacancies, and the Constitution is very clear in Article 99B that in respect.
Abusuan mu bibia kwa bamfambra kwa Mjenti TV so ewo YouTube so ase abusuan betimi so asa afili ewo eye TikTok e dia aka ho ni nyina kwa Mjenti TV. Abusuan aba ensama hodo bia ekoso ewo Ghana hase no ane yabobo bia no ero abesom eye obi biara o hwe eye YouTube channel we meso so adaruma ene edi dinkan na wo hwe a obe subscribe dia mai ebi so a wota hwe na onya subscribe ya obu ni ndi kwa so na odon sabo subscribe button so we are now the bell notification icon so ato all sede be ya next time bia na drop video on sabeka video in 10 times na ma bibia kama ebusua yenko ni nkutie ensem ne fambre ba be di ensem no nkomo sede sitie wo comment bia so abeti ma chewa adwen o comment section wadaroma no ama ho ate e de ama mekenkan ma bibia ay kama
students okay right. But so let's take the case of an order by the magistrate court, right, or the rent magistrate for the eviction of a tenant because the tenant has defaulted in the payment of rent, right? The magistrate gives an order for the eviction of the tenant, and then the landlord goes with bailiffs, to get the tenant evicted. That is an example of an executable order, right? Because it is an order made from a judicial authority, okay, which has the power of law to affect rights and liabilities, okay? And therefore, when it is made and the person who is affected wants to contest the order, that person will then come to court and say, look, I want the order stayed and not executed against me so that I can proceed to challenge the judgment that was rendered against me.
Right, so that you guys are running away from quote unquote calling it a ruling or an order of the speaker because he simply said I'm bringing this, announcing and bringing.
No, but let me.
So let's say what that means is what the speaker did. You don't need any other further steps to enforce it.
Right.
So it's not executable.
That's basically what I'm saying. But even if we were to call it a ruling, all right, it must be a ruling by a judicial body or a quasi-judicial body. Okay. All right. And so I want to, for a judicial body, I'm sure everybody understands that this is a court of competent jurisdiction. A quasi-judicial body may be an administrative tribunal.
Like Shraj,
for instance. All right. Or, and this is very interesting, let's say a committee of parliament. If you look at the Constitution, committees of parliament have the powers of the High Court to enforce attendance of witnesses and then to hold people, for contempt. So if a committee of parliament, makes an order for someone to, a witness to attend upon it, and let's say the witness decides not to attend
or produce
documents, and they default in doing so, that is an order which is executable because under the Constitution, the Committee of Parliament has assumed the powers of the High Court, and the High Court is a judicial body. Okay, so Parliament as a whole, all right, as we all know, is a lawmaking body, is a legislative arm of government, all right, and matters ensuing from Parliament, if there are not acts and omissions that can be brought within the ambit of Article 2, of the Constitution for either interpretation or enforcement, all right, you cannot say that, let's say the High Court will say, Mr. Speaker or a committee of Parliament should stay, taking a step in order for the person affected to then, vindicate his rights in court. That is an anomaly. And so the Supreme Court erred on that ground because the subject matter of the so-called a judicial order or a quasi-judicial order that can be stayed.
That's point 2.
All right. Now, when it comes to jurisdiction, again, their lordship erred. Okay, because the Constitution is very clear.
But when there is, before you move on,
right?
When there is a judicial order, before you are able to stay that judicial order, you must have an appeal.
Yes, so you have to file a notice of appeal. All right. I didn't want to go into all those nitty-gritties because in the case of Parliament, okay, the Honorable Afenyo Markin was on his feet, and he wanted to adopt an unusual procedure to respond to Mr. Speaker. And Mr. Speaker said, no, you cannot. When the Speaker has made, rendered his ruling or response to statements from the floor, no member, can get up and rise on his feet or her feet and then either challenge Mr. Speaker. If you want to challenge Mr. Speaker, you have to come by substantive motion. But you cannot also, rise up and now comment on what Mr. Speaker has said. That is the procedure and the practice in the House. So when he wanted to challenge Mr. Speaker, Mr. Speaker told him that, he was not going to give him leave to challenge him. So there was no appeal, properly so-called. There is no notice of appeal before any, court of competent jurisdiction for there to have been a stay, of execution. All right. Now,
in fact, and we are putting the facts out for you as far as we know them. In fact, the suit was instituted on the 15th. The Speaker's decision was taken on the 17th. Correct?
Right.
Thank you.
Now that is also one aspect which I will come to shortly. But I want to deal with the issue of jurisdiction. The reason I'm talking jurisdiction is because this is very important. The subject matter of the suit before the Supreme Court relates to the declaration of vacancies. All right, because Mr. Speaker had said that vacancies had occurred in these 4 constituencies, and he was informing the House pursuant to Order 18 of our standing orders that vacancies had occurred. Now, let's even say that the suit that was filed prior to the response of Mr. Speaker or the ruling of Mr. Speaker correctly identifies the act or omission of Parliament that has to be dealt with by the Supreme Court. All right. The issue that it is raising is one in relation to the declaration of vacancies. And the Constitution is very clear in Article 99B that in respect of declaration of vacancies, it is the High Court that has jurisdiction. So at best, the jurisdiction of the Supreme Court in this matter will be a reference jurisdiction in the sense that when the suit is pending before the High Court and a matter of interpretation arises from that suit, then the High Court will stay its hand and the matter can be referred to the Supreme Court for interpretation, and then the High Court will now be bound by the interpretation rendered by the Supreme Court. In this particular case, the Honorable Afenyo Markin is alleging, okay, that there are issues of interpretation, all right? given the fact that his suit was filed even before Mr. Speaker's ruling, I had said on the floor of Parliament that it was drawing the court's attention to a hypothetical situation. Okay, and you know that in Bilson and Apollo, the court was very clear. If you read Pega JSC's, judgment, the court was very clear that the Supreme Court does not deal with hypothetical situations, but it deals with actual controversies. All right. In this particular case, what was the actual controversy prior to, okay, Mr. Speaker rendering his ruling, or his response to the statement made by the Honorable Atufosin? There was no actual controversy. Okay, and then also, what is there to interpret? You say that you are inviting the court to interpret Article 97G and H. Something, the language of Article 97G and H are very clear. The question is whether or not the acts, engaged in by the 4 MPs fall within the ambit of Article 97G and H. That's the sole question. And that is a question of evidence that properly belongs to the High Court under Article 99 of the Constitution. So the Supreme Court clearly erred, did not have jurisdiction in this matter.
But they have not gone into that matter yet.
No, but you see,
as it is, they have not gone into that matter yet. To determine first whether there is a matter to be interpreted, because the interpretation, as you said, will only kick in. The interpretive jurisdiction of the Supreme Court will only kick in when, in fact, these provisions, there is some ambiguity, there's some lack of clarity about them. But if read and their ordinary meanings are clear to everybody, the Supreme Court will tell everybody that there's no need to interpret them.
You see, usually when courts are dealing with these preliminary applications and so on, they tend to deal with them, in a narrow manner within the context of, let's say, the application for injunction or the application for stay of execution, as was the case here. All right, but something, you see, if you file papers, all right, if you file papers, the court is, the court may not come to a decision that is, like a judgment on the substantive merits of the case, all right? But the court is bound to look at the papers that you have filed. And if I were in their case, I would have looked at the papers. In fact, the court quoted in the ruling, they quoted the reliefs that are being sought.
Yeah.
If you quote the reliefs should tell you that these are reliefs that properly belong to Article 99 and not reliefs that belong to, Article 2 of the Constitution.
Don't you find that the courts seem to agree that there are serious matters of law to be determined? Because in the ruling, they state so. And we know that in determining such applications as went before them yesterday, there are about 3 factors that the court is supposed to consider.
Right.
An important aspect of the factors is to consider whether there are the suit itself discloses, arguable, points of law.
Yes.
The court found that, yes, it does disclose arguable points of law.
Right.
The second thing the court will normally consider will be whether or not, that is whether the party has a right to be protected.
Yes.
Then the second thing they will consider will be whether or not, if they don't grant the interim measure, the process, normally is an appeal, will be rendered nugatory.
Yes.
It will be of no use in the end.
In the end, yeah.
And then they will ask the question whether there is special circumstance
meriting the grant of the...
And you find in their ruling that they state so. They said, for example, that the agency and special circumstances lie in the effect of the impugned ruling, which include 1, depriving the 4 constituencies that said MPs presently represent, then he names them,
of the
that
right,
the said
right
4 constituencies in the Ashanti region, blah, 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 regions have been deprived of their basic democratic and constitutional right of representation in parliament until the next parliament by the said ruling. They said that if this impugned order and ruling is allowed to stand, it will render the grave issues raised in the substantive action nugatory.
Well, you see, that is well said, okay? But to be able to do so, you must first of all be right in assuming jurisdiction. Okay. Yes. So if it were the High Court saying these things, I would have no problem at all with what they have said. Okay. But I still go to the point that the Supreme Court lacks jurisdiction in this matter, despite the fact that Afeyo Makin might have cloaked his suit, in the gap of an interpretative, action or an action for the interpretation of the provision. I still think, that is Article 97. Okay, I still think that.
So if you don't mind, I'd like you to hold on.
Yes.
Let me go to my other guest and return to you later. Yes, Honorable Habib.
Yes.
People are saying the ordinary Ghanaian, apart from some of your members, are shocked that not long ago you were excited about the same approach by Speaker Okwe. You didn't say this is an interpretive matter. Speaker Okwe should wait until the court has done an interpretation. Now you are insisting that Bagbin has done